So what I realized is you put it in your words. Don't try to use their words, because once you study their words, you're like, holy cow, everything that I was taught is like backwards. If I use their words, it sounds ridiculous to the common man. So you know what? I'm just going to use the common words that the people, because I'm going to go before a jury. So what I always say to people is you make your lawsuit incredibly short because the other side already knows what they did wrong to you. The court clerk isn't supposed to read your paperwork. The folks in the black robe are not supposed to read your paperwork. The only person who's supposed to read your paperwork is the person that you're prosecuting, the person you're going after, suing. He already knows what you did. Now, he has the right to say, can you please hand me a more itemized statement of the facts? But you don't have to. You could just say to him, you administrated like me, and said you uttered a forged instrument which interfered with my rights to property. And then the next thing was like, now I demand compensation. There you go. That's my lawsuit. He knows what uttered forged instrument he created that interfered with my right to property.
Mm-hmm.
Need to know anymore? Well, I did put C Exhibit C, so he could actually see the forged instrument. But he knew. They know. And that's it. And the federal marshal said to me, that's it? That's your whole lawsuit? It's like, yeah, well, I put a bigger one before the court. It was 4 pages long, which was 3 pages more than I needed. I said, but, well, I needed this cover sheet, so it was 2 pages more than I really needed. I only really needed this one sentence, basically, in this 1 page. They were like, well, this is so simple, it's ridiculous. I said, yeah. I said, do you understand this? And they looked at the Exhibit C, and they're like, okay, they read it. It's like, you're absolutely right. This doesn't have your name on it, your wife's name on it, or your child's name on it. This has some little old lady's name on it. 80-year-old lady says on here, Uncle Charlie, 40-something, and some girl, 3 years old, living in an apartment. What does this have to do with you and your newborn? I said, absolutely nothing. But they just jammed it in a case file. They picked one out and just jammed it in there, and they figured if anybody ever looked into the case file, they would see a contract. And they thought that we'd get away with it because they never gave me or my wife access to the case file. The court that is actually filed in, the family court in Jefferson County, they still have never given me a copy of the case file. But the clerk of the court at the Alabama Court of Appeals at the Supreme Court of Alabama, he gave me a copy of the case file, which is ridiculous to have to go. And even he said that. He said, this is the most ridiculous thing I've ever heard. The clerk of the court is supposed to release it to you. I said, yeah, well. And he was on the phone with me and the clerk of the court. She kept saying, oh, yeah, well, we thought we put it in the mail. So for 6 months, him and I were calling up the clerk court for the family court, and they never released it. They're never going to release it to me. So, like I said, I hear a lot of these folks saying, well, just how wonderful court clerks are and stuff like that. Well, sometimes if they don't want to abide by the law, they're not going to abide by it. So you can file all kinds of motions and petitions and everything, and they're just going to laugh at you. So when they really want to stack the deck against you, like I said, the only way you're going to be able to do this is go and take it to the common law side of the court. And there's a guy named Tom Murphy out there and Janet Marie. And I'm trying to get these folks out a little bit older than me. And I'm trying to get these folks to go to their county commissioners, and when the public courts can be made available to move common law claims, because, say, the common law claims side of the community is not being heard by this private bar member association setup that we have in this public building right now. They're taking it. It's like walking into a public library at 8 o'clock in the morning. All the lawyers, all the judges, everybody takes all the computers and reads all the books in the public library. They're like, hey, we're not having access to this public library. They're taking all the tables, all the computers, all the pens, they're taking everything. When can we have access to this public library? And they're like, well, tough. We're here first. We got here first. We're taking it over. This is our building now. But maybe, like Janet Marie said, well, Huck County Court shuts down from 12 to 1. I said, well, there you go. You go to the county commissioner, and it's just like the folks leaving the library. They leave the library at 12 o'clock to 1 o'clock to all go to lunch. Take over the library. Read all the books, read all the books, take over the computers, take over the tables and desks, and have at it. So I said, there's no reason why you can't go to the county commission and say, well, the common law side of the court is not being heard in this public courthouse. This is a public courthouse that my great-grandfather built and everybody's grandfather built and taxpayers' money paid for. We would like to use this court from 12:15 to 12:45, 2 days a week. I said, just get your foot in the door and just say, this is a public building. We'd like to use the facility. And when the court clerk comes back from lunch at 1 o'clock, we'll hand her the rulings, and she can file them for us in her fancy vault. and put it on a public record for us. I said, start with simple things like that. I said, because these little ladies can make the magic happen. I can't. They take a look at me and saying, well, I want to take over this court from 12:15 to 12:45. It's like, why? So you could steal all the paper and pencils, you could unbolt the chairs and walk out the door with them. So I said, a little old lady could probably get away with asking to use the courts. Like, we'll provide the clerks, we'll provide the retired judges, we'll provide the jury, we'll provide a lot. We'll provide our own paper and pencil, we'll provide our own, court reporter, we'll provide all the stuff. While everybody's out at lunch, we're going to take care of the common law side of the court. Because nobody seems in this community or in this courthouse to care less about moving matters through the common law side of the court. Everybody wants to do administrative side. And we're not being heard, and this community needs to be heard. And the people in this community need remedy that they're not getting from the Bar Association that takes over this court from 9 to 5. So see, that's what I'm saying. That's Tom is doing that, and Janet Marie lady. And I'm trying to convince these folks, this sounds pretty simple. It's a public building. You have every right to access it. And nobody has the right to deny you access to a public building. It's not private. And everybody starts saying, oh, it's a private court. Oh, yeah, who paid the building to be built? A private corporation paid for the building? No, I thought this was a public court. So paid with public tax dollars. Why can't we access it just like a public library? Does that kind of make sense to you?
Yes, it does. It's a great idea. As a matter of fact, I kind of did turn in, and it was to be just as an idea for them to contract to be able to do the common law and let us do our own common law courts in the building. And they ended up putting it in as part of a part of the order, the injunction against them taking our home and property prior to this being decided in this common law case. And that was wrong too. So I guess I have to address that specifically, because if they can give us access to the common law side of the court and we can do our own thing without their personnel, just use the building like you said.
Well, like I say to folks, one of the best things to do is that when you're making a notice to the court, make it one notice at a time, one sentence at a time. Even if you have to file 10 notices, that's fine. Don't combine all your thoughts on one piece of paper. If they don't like one, they're going to strike out the whole paper.
I see. Okay, so you're saying do several notices, reference corrections, perhaps reference how this was misfiled.
Right.
Okay. Well, I can understand that. That makes sense to me.
Right. It's like ordering something a la carte. You want to order each separate order, one at a time. If you just say, I want the shrimp, the meatballs, the pepperoni, the ham sandwich, the gefilte fish, I want the Alaskan king crab, and they'll just say, we can't fill that order for you. Too bad, denied. It's like, okay. How about this? How about you give me an order of gefilte fish and Alaskan king crab and make an order for spaghetti? It's like, well, we could do that order, that order, that order. We don't have that. We can't do that. We don't have jurisdiction or control over that. We have no authority over that one. Okay, but no. You see how you break it up? Instead of saying denied. Instead of just making one swell full saying denied. You make many separate orders, many separate notices.
Now, I thought I asked the question regarding whether you do common law, just all lowercase. I think I noticed that you had a dash between the two words, and some people capitalize C for common and capitalize L for law. Does it really matter? Does it have different definitions based on how you write it?
Nope, because if anybody wants to object to something that you're writing, that is your beliefs. That's your contract. That's your right. So you could basically you could let a chicken tap dance on a paper, and the other side's obviously going to come back and say, what does that word mean, or what is that scribble? What is that? And then you have to clarify for him. If he doesn't object to what you wrote, then it's whatever you believe is true. Because like I said, if you folks answer to their code, because the judge always asks you, do you understand your rights? And everybody says yes. It's like, oh, goody. We're good to go. It's like, okay, because you understand what that code book reads, right? It's like, that's basically what the judge says. You've been charged with code 1, 2, 3, 4, 5, 6, 7. You understand your rights. And everybody says yes.
You want to say no.
Of course not. I didn't write the book. I have no idea. I didn't study that book. I have no idea what that code means. What are you talking about? Where are we going with this, Judge? And he's like, well, you know what I mean. It's like, no, you said, do I understand what rights I have under this code? What code? Like I said, you just say to them, that's ridiculous. That's too much for me to know. I don't possibly have that right. But if we move this to the common law side of the court, well, then I understand my rights. But this side of the court, I have no clue what you're talking about. Because I'm not a code decipherer. I don't have somebody to decipher the code for me. Like, I don't have a legal attorney to decipher the stuff for me. And so, no, I'm going to have to say I have absolutely no idea. I am totally incompetent in your code. And they're going to say, well, do you want somebody to come and decipher it for you? Do you want an attorney? It's like, no, you know what? I think I'd probably be better off if I just move over to the common law side of the court.
Mm-hmm.
And you're just nice and polite. You're just nice and, I mean, was that as nice and polite as pie as I could possibly be?
Yes, indeed.
That's the whole trick. You just be as nice as polite as pie.
Mm-hmm.
You don't get confrontational. Like I said, a lot of folks jump up and down and say, I know my rights and I got the Constitution and you're going to do it this way. If you don't do it this way, I'm going to sue you and everybody else and blah, blah, blah. No, the judge is going to ask you, do you understand your rights? Do you understand that you're waiving your right to a trial by jury? Do you understand your right? Did you waive the, I don't know if you've been before a judge before. I've been before plenty of times. And that's what they always ask you. Do you understand you're waiving your rights? Do you understand you're waiving your right to this? Do you understand you're waiving your right to this? Like, yeah, okay. What do you mean, yeah, okay?
No,
you don't want to,
right.
but people don't want to make the judge upset. So they just say yes. And they get themselves in a lot of trouble by saying yes. You see what I'm saying?
Yes, I do see what you're saying.
There's nothing wrong with telling the judge, no, I have no freaking clue.
It sounds to me like I maybe should go back and void the order and judgment in the unlawful detainer case where they've done this writ of restitution.
Okay. Is that your order that you put before the court, or is it their order they put before the court?
It was the attorney's order, and then the judge signed it. And we did send it back when they they never even mailed it to us. They just did it when they evicted us from the house. And that was like a month later. And so I sent back do not consent.
Who wrote the order?
The attorney for the other side, who actually had disqualified by their own admissions, which I put into not only the court record, but also into the public record, because they never verified their position and their authority.
I should have a buzzer next to me just so I could say, people, time out. Okay. An attorney can't create an order. An attorney could propose, like a proposal, like you're getting a wedding proposal. An attorney could propose an order. Okay?
Yeah.
So the judge, the man in the black robe, looks at the attorney's proposal, and he's either going to grant it or deny it. So, who created the order? Now, are you saying that the attorney for the other side proposed something to the person in the black robe, and the person in the black robe granted his proposal?
That is correct.
Okay. What did the proposal basically say?
The proposal was to give them the writ of restitution, permanent writ of restitution, to essentially evict us from our home, even though we had paid for the trial by jury, and even though the judge had earlier said that we had not responded to something that the attorney had put in, and it was something we never even received. So the judge was trying to hold us responsible for something that had never been, that we never knew about. And so I, of course, objected to that and put paperwork into that because I respond to everything. Okay, I know better than not to respond. And
when you respond, what I'm saying is this isn't just for you. This is for everybody.
Right.
You have to say, when somebody's presenting you something from the other side, you basically have to say that I do not understand what you're saying. Are you trying to convey a message to me or negotiate with me or communicate with me something other than outside of common law? Are you relying upon a statutory code or a federal rule or a state rule of civil procedure? I do not recognize civil procedure. I do not operate, and I'm not bound to answer, respond, reply to rules of procedure. I am not pro se. I'm not a subordinate officer of that court or this court. I am a man in my court in the common law. my court. It's my court. So you have to file a claim in your court. You don't answer in their court because you don't speak their language. You can't possibly give them a coherent response in their court. You can't possibly do it. You have no idea what they're trying to say to you. Like, I have no idea what you're trying to say. What are you trying to say? It's like, well, I don't speak legalese. I'm not competent to stand in your court. And I don't want somebody to decipher this for me. You know what? We're just going to, thank God this is America. Thank God this nation, we have the right to move it over to the common law side. Judge, we're just going to move this over to the common law side, okay? And then he'll have to say, you have no choice. They have to move it over to where you're competent, where you can stand. If you try to respond back to them, as far as they're concerned, you're competent. You're responding back and forth. It sounds competent. It sounds like you know what you're doing. It sounds legitimate. It sounds like it sounds like you're responding back and forth, volleying back and forth. You have to tell them you're not competent to give an answer under a statute because you aren't proficient, nor you're competent to give them an answer. You'd love to, but you just don't have the ability to do so. You're going to have to rely upon your right to move it under the common law. I can speak to you folks man to man, which is by my right, but I have no ability to speak to some sort of, legalese, bar association. I'm not proficient in their language.
I asked for the attorney's verification that they actually were representing the so-called plaintiff, and they never could provide that. I did ask to move it over to the common law side of court. That was not granted. They kept it in the administrative side the whole time.
Right.
I asked for the common law trial by jury. That essentially was denied when the attorney proposed the order, and it was signed. So I did.
The clerk of the court can't deny you a trial by jury. If they do try to, who denied you the trial by jury?
The judge, the clerk, whoever. It was never granted. I had paid for it, and I was waiting for them to give us a date and a time, and they never did. The proposed order of the attorney, they signed. I put in my thing for the trial by jury. They essentially deny it because they sign this and they don't pay attention to what I do.
Okay, so when somebody mailed you an order, how did you know this order came down at you trial by jury?
Until they came to lock us out of our home. Okay? We never received a copy of it.
Okay, is there a copy on file of an order?
Yes, there was, but we didn't know about it because it was not mailed to us. It was done on February 6th without our knowledge, and then they...
That's fine. That's fine. All you have to do, like I said, when you get something like that going on, is all you have to say to them is, you have an order that they believe that there's an order standing. All you have to do, see who signed that order, and when they sign the order, say, were you not aware that the paperwork before the court or the case before the court was to be moved under a trial by jury?
They were aware because all along I've been asking for that.
Ma'am, you gotta let me finish.
Okay, I'm sorry.
Because you already know what happened. Okay, this is what I'm saying. This answers to everybody. See, when you folks ask me a question, it's case specific, and it's not. This is for everybody. When something comes through as an order through something other than your court, you inform that other court. How did you come to this ruling or decision when it was clearly established that this was my court and that this matter was being moved through a process called trial by jury? Now, I demand of you to give me your findings of facts and your conclusions of law on how you came about with this ruling. There you go. Now, like I said, just re-listen to this thing and just write down that one simple sentence. So the person who wrote that order is going to have to say how he made that ruling or how she made that ruling. You see what I'm saying?
Mm-hmm.
You're going to try to get them neck in the noose. And they have to do it. That's part of their job. They have to tell you what legal determination or what lawful procedure did you move under, or what did you rely upon to make this ruling? Because did you not know? Did you not see my claim, my case on file through your court assigned to you before you made this ruling? How did you ignore all of my documents and evidence and filings before this court? How did you do that? How did you do that little magic act? Because, like I said, as long as you're the prosecutor, if you're the defendant, you're going to lose. The judge isn't going to look at anything.
You were the defendant in that case, so that's probably why we lost. Okay.
That's exactly why you lost. Because, well, then, okay, everybody else who heard this thing was going to listen to it in a year or two from now when they play this thing back. There you go. The lady forgot to tell me that she did not file her own claim that some bank or somebody was trying to administrate her property without right. Because that's all to do was when they came at her, say, oh, lovely, try to settle a matter on a private side with the other person, the bank. Say, look, we'll pay you $50 a month for the next, 5,000 years. They might accept it, they might not. Because at least they know you're going to keep the property upkept, you're going to mow the lawn, take care of the swimming pool, you're not going to let all kinds of snakes and lizards live in the house. Some banks actually want somebody to occupy that building. Some banks just want to throw you out in the keister and just demolish the house. They don't care. They've already wrote it off and they already got the mortgage paid for 100 times over. Whatever Fremantle, Montana, crazy currency beliefs you guys got, that's fine. But anytime somebody's coming at you with a demand or order saying, I demand this, this, and this from you, you make an offer back. And if you can't settle it on a private side, at least you keep a record of your offers to settle a matter with the other side. Because
that was actually my defense, that we had made many offers to settle.
You have no defense.
The foreclosure sale was void, and because of that.
You are a defenseless person. I am telling you. If you folks never, if you stay as a defendant, let me just put it this way. You say, I don't care if somebody wins as a defendant. I don't care. That one person out of a million who actually could come on here and say, look, I won as a defendant. Okay, well, what happened to every single other person who lost? You're only going to truly win if you're the prosecutor. So to go for the win, you have to say, okay, look, I tried to settle it with this man as best I could on a private side, or this bank, or whoever. You know what? I'm done. We did it as long as we could. The administration process is exhausted. There is no remedy. Fine. We're going to have to take this into court. You know what? He said he wants to take this into court. Let's take this into court. Now, he's going to move under this code, this code, this code, this code. I'm going to move on under common law. Thank God we're not in France, because every single thing I'm telling you, you would lose in France. This only works in, this nation. It does not work in France or Italy or Germany, because they abide by codes. Their code is their precedent. Their superior law is code. Our superior law is the common law. Thank God we live in that nation that still believes in man is superior to the government. Over there in France, it's not. So all you have to do is explain to the judge, well, now, like I said, you have to make a claim that the court moved in error, that you had the right to a trial by jury. And take a look at the order and tell the judge, why was I denied the right to a trial by jury? He's going to probably make it really simple. And he's going to say, well, this case was moving under statutory code 1234. And under section 1234, there is no provisions of a trial by jury permitted or allowed or accepted. It doesn't happen. It doesn't exist under this code. So that's basically what his answer is going to be. So you forgot to throw that little thing to me that that's from now on I'm going to ask everybody the first thing. Were you defendant or you plaintiff? Or were you the prosecutor or you were the wrongdoer? Which one were you? So that way I'm not giving you an answer presuming like I would never walk into a court without being a prosecutor. I would never do it.